So mediation is an opportunity to compromise, to give up some rights in exchange for a deal you can live with, a deal that may be fair and reasonable. Don't look to get what's fair down at the courthouse. A wise judge once told me in a mediation that fair is what you get in Dallas in September. What you get at the courthouse is reasonable, because down at the courthouse, this is fourth quarter. Let's say the case didn't settle at mediation. Now you're in the fourth quarter. Game's on the line, 15 minutes to go, and it's winner take all. At the end of a trial, somebody will win and somebody will lose. And that's what you're asking a jury or a judge to do, is to determine winner or loser. And the fact of the matter is, you may get a reasonable result that isn't fair, or doesn't feel fair, or seem fair, or maybe wasn't as fair as the result you were offered at mediation. And I've seen that happen in the past. But the bottom line is, what happens at mediation is different from what happens at trial. And the reason why is because what happens down at the courthouse is you're locked in. You know, you're locked in by the rules of evidence, by the rules of procedure, by the code of procedure that controls that particular area of law. If it's an estate matter, it'd be the Texas Estates Code. Family matter, Texas Family Code. The Texas Rules of Evidence, Texas Rules of Civil Procedure. If it's a criminal matter, it'll be the Code of Criminal Procedure and the Texas Penal Code. And those are going to be those laws which are not promulgated by the judge. The judge did not write those laws. Those laws were written by the people we elected down in Austin. And they've evolved over the years. But the judge is blameless. The judge has no discretion but to enforce those laws. So when you step into that boxing ring that is trial, that is especially jury trial, the judge is going to be locked in by those parameters and will have no discretion but to follow those rules of evidence, those rules of procedure, and keep out evidence that may be favorable to you, keep out evidence that may be favorable to them, let in evidence favorable to them, keep your evidence out. It just will depend on how the facts play out in the case and what the judge decides is relevant and what the parties can get into evidence as believable, credible, admissible evidence. And then you ask the jury to weigh all that evidence and get a result. And then again, maybe a result that's reasonable, but not one that feels fair. So think long and hard about getting all the way to the fourth quarter and winning it in the end. And there's nothing better, there's nothing better than having a jury vindicate you and grant you every request for relief that you made. And likewise, there's almost nothing lower in this business than having a jury disagree with you and not grant any or only grant limited requests for relief that you made. And that stings. And that doesn't feel fair. So these are all reasons why lawsuits can take a long time. They can take a long time just in their initial stage, when they're incubating, when the lawyers are planning and preparing to bring the case into litigation.